Great. A very good morning, everyone. Welcome to the fifth session of this course. Today, we don't have a very long class because it's very clearly a drafting class, and most of these clauses are repetitive, as you will see as and when we keep proceeding in the class. But as discussed in previous classes, if at any point in time you have a question, you can always interrupt me, and you can ask me those questions so that I'll be able to answer it then and there. So without further ado, let's get started. Now that we have in the first class seen what share purchase agreement and asset purchase agreements are, let's get into understanding how they are ideally drafted. So to give you a quick insight, we'll start off with what the key clauses are. So let's start with a share purchase agreement. So the key clauses in a share purchase agreement would first be definitions and interpretations, which will define your uh, key terms like, I'm sorry, something just went into my eye. Uh, your key terms like shares, company, consideration, closing date, etc. And also, of course, you will follow that. I'm sorry, before that, you also will define terms like warranties, following which you will have a clause which will talk about sale and transfer of shares, which will specify three things. First is first is the number and types of shares that are to be sold. Second is an identification of the seller and buyer. The third is it will include the conditions precedent to transfer. I will tell you what these are once we get into wording and understanding how each clause is drafted. I will be, as the fourth part of today's lecture, we will have a sample that is displayed, and we will understand how these clauses are exactly drafted. So don't worry about that. For now, just get a theoretical understanding of what these clauses particularly entail. The third clause will be your purchase price and payment terms, which will ideally include consideration payable, a mode of payment, earn-out provisions, if any, and currency. So these are just adjust. So these can also include adjustment mechanisms. For example, working capital adjustments. On the fourth bit, you have your conditions precedent, which basically lists actions to be completed before closing. For example, board or shareholder approvals, regulatory consents like RBI or SEBI in some cases, third-party consents, etc. You will then have your warranties and representations, which will basically again be which we can understand in a three-pronged manner. Firstly, the warranties and representations are made by the buyers about the made by the sellers about the company, which will include the legal status of the company, the financials, the compliances, and any litigations, if any. And this is just to ensure that the buyer is indemnified against any prospective legal non-compliance or legal risk in furtherance to the purchase of shares of this particular company. Then, of course, your warranties and representations can be extensive in Indian share purchase agreements because of the buyer's reliance solely on due diligence. And it also includes sometimes buyer's representations that they are not insolvent, or they don't have any pending actions for debt recovery against them, etc. Because you do not want, or of course, any ongoing case against them, and if any, those have to be disclosed. And then the seller will, then the seller will have to assess whether these are material to the, to the how do I put this, for the lack of better language, to the purpose of the transaction. And if it is going to put the company in some sort of risk because it is being held by someone who is probably insolvent, or being held by someone who is not legally compliant, or who is an offender in the eyes of law, and proceedings are ongoing against them. So that those are basically what buyer representations will include, and those have to be disclosures that are to be made to the seller. The sixth clause will particularly be indemnity and limitation of liability, which will basically be touching upon two things. First is it will cover losses due to breach of warranties or misrepresentation. And second is it sets limits on indemnity, like cap, threshold, survival period, etc. You then have your covenants, which will basically be which can basically be understood in two different categories. One is your pre-closing covenants, and the other is your post-closing covenants. So your pre-closing covenants will basically include things like maintaining business as usual, no new debt, etc. And your post-closing covenants will include non-compete, confidentiality, etc. And then mostly your next clause would ideally be closing and deliverables, which will basically specify what occurs at closing, like share transfer forms, payment, board resolutions, share certificates, etc. And you will then have your non-compete and non-solicit clauses, which will basically prohibit the seller from competing or soliciting employees or customers for a specific period of time and territory. But you have to ensure that it is reasonable under the interpretations of Section 27 of the Indian Contract Act of 1872. And you have to, like, basically, you need to ensure that it is not coming as a restrictive covenant, right? Like the period of non-compete and non-solicit, if necessitated as well, because of the sensitive nature of the transaction and the significant stake that is involved in a transaction, which is definitely the higher the shareholding, higher the stake. Uh, you just have to make sure that whatever is the non-compete and non-solicit period is not for an unreasonable period of time. Now, unfortunately, I can't give you a very demarcated and specific understanding of what reasonable and unreasonable is, because this is something that is left to judicial interpretation on a case-to-case basis. Because it can be like maybe non-compete for 2 years would be reasonable if there's a share purchase of maybe say 25% or 20%, and at the 20 to 25%. But again, if it's a share purchase of maybe 51%, then 5 years of non-compete or non-solicit, if I were a judge, would be reasonable to me. But again, if it's a 1% or 2% share purchase, then if you're putting a non-compete of maybe say 2 years or maybe 3 years, then that would be unreasonable and that would attract risk under Section 27 of the Indian Contract Act of 1872, which will basically regard it as a restrictive covenant. Then you have your dispute resolution and governing law clause, which will basically include your arbitration clauses. And of course, since it's in India, it's often under Indian Arbitration and Conciliation Act of 1996. Then you will have a governing law clause under this ambit itself, which is basically Indian law. And of course, if you want to talk about any courts having jurisdiction, you might want to refer to a specific state under which the jurisdiction of which would have the jurisdiction of which would basically be capable of taking up these cases. I'm sorry, somebody unmuted. Is there a question? I felt somebody unmute. Okay. If there is
Sir,
yeah, go
I'm
ahead.
Ria. I'm sorry, so sorry to disturb, but your slides are not moving actually. They're not changing.
No, that's only because I'm on the same slide.
Oh, okay. Sorry.
If I'm to move, I'll let you know. Don't worry. This is just the first topic.
Okay.
Yeah. You then have your tax clauses, which are basically allocation of tax liabilities, which will basically be allocation of tax liabilities like capital gains, indirect taxes, etc. And of course, you will have obligations such as withholding tax obligations, especially for cross-border deals. Somebody raised their hand. Okay, I heard a sound, that's why. Right. And then you have your 12th and 13th clauses, which will basically be confidentiality and announcements and termination respectively. So confidentiality and announcements will basically govern publicity and disclosure of the deal before and after execution. And termination will specify grounds of termination and consequences thereof. Then coming to key clauses in your asset purchase agreements. Again, much like your SPA, you will have very similar clauses. It's just that instead of your shares, you will definitely have your second clause representing transfer of assets. Excuse me. So again, I will go clause by clause only, so that you can note down, because of course, terms of like definite defined terms will be different. So your first clause will ideally be again your definitions and interpretations clause. Like in every agreement, you will terms like assets, assumed liabilities, excluded assets, etc. will be defined. Then your second clause will be your transfer of assets, which will specify the assets that are to be transferred and like that is tangible, intangible contracts, goodwill, etc. And would also list excluded assets if any, if it is a bulk transfer of assets. Then you will have a third clause, which will be of assumption of liabilities, which can be understood in twofold. First is it will be outlining the liabilities the buyer agrees to take over. The second is it will often exclude legacy or unknown liabilities unless expressly assumed. Excuse me. Then comes consideration and payment terms, which will be your fourth clause. Very similar again to the SPA. You'll detail the asset valuation, apportion, and like also provide the apportionment of value to different asset classes, and also you will have a payment schedule and withholding taxes. And then you have, of course, your conditions precedent, which is similar to the SPA, but may include sector-specific approvals like factory licenses, environmental clearances, etc. Then you will have warranties and representations, which will basically be specific to assets like title, encumbrance-free status, condition of machinery, IPR ownership, etc. And it will have fewer company-level warranties than in SPAs. The your seven clause will, of course, very similar to your SPA again, be your indemnity and limitation of liability clause, which will basically be typically robust in any asset purchase agreement because of higher risk of unknown liabilities and asset transfers, and it will often include third-party claims and indemnities. Third-party claims indemnities. I'm sorry, my bad. I correct myself. Um, You will then have covenants. So you will ensure that there is continued operation until closing and that non-compete and transitional assistance by the seller post-sale is in place. Then again, in an asset purchase agreement, very important, this is one peculiar clause that you will have, which will be needed, is a transfer of employees clause because it's an asset purchase. So you will typically, there's basically Section 25 FF of the Industrial Disputes Act of 1947 that we discussed last class as well, which will become relevant because retrenchment of employees will be happening or transfer of employees will be happening, succeeding that retrenchment, right? So you will have to retrench the employees first, and then maybe you'll have to like they'll be rehired as and when maybe needed. So they're being laid off by a previous entity. So in that, or like being, or they're just being hired by a new entity. So you will, so that's why Section 25 FF will come relevant, and the seller will need to discharge gratuity and other terminal benefits as the workers who are eligible under the Industrial Disputes Act will be eligible, as the workers eligible under the Industrial Disputes Act will be entitled to. But of course, unless agreed otherwise between the workers and the employers. Then, of course, you have your tax implications clause, which will basically indicate your GST, stamp duty, and capital gains that must carefully be structured. And also in this, your tax apportionment clause is critical. Uh, then is your assignment innovation clause, which was basically for contracts or licenses to be transferred, and consents from third parties may also be required. So with those being the major clauses, the minor clauses will, of course, be your dispute resolution and governing law, your closing mechanics like transfer deeds, delivery of physical assets, IP assignment documents, etc. And then will come your termination, which will basically include provisions similar to your share purchase agreement. So how exactly, apart from your subject matter or subject of transfer, will your share purchase and asset purchase agreement differ? I think that's a question that a lot of you will have. So we can categorize this, apart from, of course, subject of transfer, into four broad parameters. First being the type of warranties, second being liabilities, third being employee transfer, and fourth being tax and stamp duty. So for type of warranties, firstly, under a share purchase agreement, it is company-wide, that is corporate and financial warranties. And under an asset purchase agreement, it is asset-specific, like title, quality, IPR, etc. Then for liabilities, in a share purchase agreement, the buyer takes all the liabilities. But in an asset purchase agreement, as we had discussed in our previous classes, the buyer only takes specified liabilities. Then comes employee transfer. It is automatic with company in a share purchase agreement, but it needs separate processes and consents under an asset purchase agreement. And as far as tax and stamp duty go, under a share purchase agreement, there are capital gains with no GST and minimal stamp duty. But under an asset purchase agreement, there's GST and there is stamp duty on on asset classes. So of course, you're going to end up paying a lot more stamp duty as well as uh, excuse me, and you're going to end up paying a lot of stamp duty on asset purchase agreement as opposed to your share purchase agreement, because you're not going to be like as mentioned, your stamp duty is going to be based on asset classes under an asset purchase agreement, but as under share purchase agreement, it is going to be on the agreement as a whole. But of course, for your taxes, I think you're going to end up paying a capital gains tax under a share purchase agreement. So I mean, obviously, because you are acquiring shares, and that's definitely in itself like a fiscal benefit. But under an asset purchase agreement, you're just paying because it's going to be treated as a good. Your asset is going to be treated as a good. I mean, and of course, certain assets, if necessitated, may be classified as service. But I've not really come across any significant ones being classified as service in practice as an asset. So your GST will apply because of the assets being goods, and you will obviously end up paying a lot more tax in the form of capital gains if you are purchasing shares as opposed to assets. So the second part of today's lecture, which brings me to the second slide, is representations, warranties, indemnities, and escrow mechanisms. But before that, if there are any questions, please feel free to ask. Yes, Amrita. Amrita, you raised your hand.
Apologies, sir. It was by mistake.
Oh, it happened by mistake. No worries. Any questions?
No, sir.
No, not you. I'm just asking everyone in general. Okay. Let's go on to the next topic then. So, in Indian M&A transactions, whether structured through a share purchase agreement or an asset purchase agreement, the core protective framework for the buyer comprises of representations and warranties, indemnities, and escrow mechanisms. So each of them serves a distinct legal and commercial function, which is basically to allocate risk, ensure disclosure accuracy, and secure post-closing remedies. So as far as representations and warranties go, by definition, representations are statements of fact made by a party, which is usually the seller, as of a specific date, which is typically the signing or closing date. Warranties, on the other hand, are promises that a particular state of affairs is true, providing a contractual basis for remedy if the statement proves false. So why is this necessary? So there are three reasons that I can understand. Excuse me. So first is it allows the buyer to conduct risk assessment. Second is it serves as the basis for indemnity claims. And the third is it encourages full disclosure by the seller. So what are the common representations and warranties then? I'll structure it this way for easy understanding. I will give you the SPA's corresponding representation and warranty, and then the APA's corresponding representation and warranty. So this is easier for you to understand. So under an SPA, you will have title to shares and valid issuance. But under an APA, you will have title to assets and no encumbrances as a representation. Then, I mean, I'm sorry, I'm just putting it in broader terms for your understanding. If you have any questions, just ask me, right? Because if I just go on to tell you that, when I say title to shares, valid issuance, title to assets, and no encumbrances, I think it'll be foolish of me to explain it in a way where I would say title to shares basically means that you will be complete, you have the valid title over those shares, and no other person, there's no joint ownership or co-ownership, and if any, you disclose it, and it is solely your title, that is your name attached to it, and therefore you are issuing it validly, and there are no prospective risks that are associated with it, and you have not obviously sold it to anyone else, and hence the issuance becomes valid. I don't think it's right for me to just spend so much of time on it and explain what title to shares is, or valid issuances, or what no encumbrances are, right? So but at the same time, that doesn't mean that some of you can, like, need not have confusion over things that I would say. So if there's any if there's any difficulty in terminological understanding, you can always interrupt me and let me know. I'm going with the assumption that all of you all can understand basic legal terms like a title, encumbrances, and when an issuance is valid, etc. So yeah, this is one caveat that I wanted to give. So moving on, under an SPA, you will have representation or for a no undisclosed liabilities, and under an asset purchase agreement, it will be the asset condition and sufficiency. Then you will, of course, under your SPA, you will have your warranty, which will be, I'm sorry, you will have a representation which will be financial statements being true and fair. And under an APA, you will have it with respect to ownership and transferability of the intellectual property rights. Then, of course, you will under an SPA, you will have a representation for full compliance with laws and litigation, and no pending litigation. And under an asset purchase agreement, you will indicate no violation of laws in respect of the assets themselves. Then, of course, you will have a representation on no material adverse changes, or a representation or a warranty on no material adverse changes. Sorry, representation and warranty on no material adverse changes. My bad. It's like something I went wrong with. I have corrected myself. And then your asset purchase agreement will have a representation and warranty for no material contracts breached due to transfer. Your share purchase agreement will have for tax, you all will have a representation and warranty on tax filings and dues being complete. And for asset purchase agreement, you will have a representation on warranty on no tax lien on assets. Yes, somebody unmuted. Is there a question? Okay. And of course, coming back to what I was saying, and under an asset purchase agreement, you will have no tax lien on assets. I mean, you will have a representation and warranty to that effect, is what I'm trying to say. Then under the share purchase agreement, you will have employment matters, ESOPs, and benefits related representations and warranties. And under an asset purchase agreement, you will have labor liabilities related to transferred employees, ranging from retrenchment compensation all the way up until payment of your gratuity, etc. And then you will, under a share purchase agreement, you will have intellectual property ownership and use, related representation and warranty. And under an asset purchase agreement, you will have a valid IPR title and no infringement claims related representations and warranties. The question that then stands is, what are indemnities? So indemnities are basically contractual promises to compensate for specific losses resulting from breaches of the share purchase agreement or asset purchase agreement, including false representations or undisclosed liabilities. So you have representations and warranties that are obtained. So beyond like disclosures in the representation and warranty, if there is something that goes wrong, you will need an indemnity to protect you there. So why exactly are these indemnities triggered? So firstly, these can be triggered because of breach of warranties. Secondly, because of tax liabilities. Thirdly, because of litigation that's undisclosed, or prospective litigation that may come into place because of some non-compliance that has not completely been disclosed, or that's not been assessed, as a result of which, of course, it was not disclosed or not asked of, or even standalone independently otherwise. Then comes your non-compliance with any other laws that are there in place from time to time, etc. Then you have in indemnity clause, what you have is indemnifiable losses that you ask for, wherein you indicate your actual loss suffered, which will include fines, penalties, legal costs, etc. And also you have a cap and basket rule. So basically what I'm trying to say is, you will have a maximum limit on the indemnity, which is usually linked to the deal value, which is your cap. Your basket is your minimum threshold before the indemnity kicks, which is like either a tipping or a deductible basket. You also have a survival period over here, which will basically be time limits for bringing claims, which is in the case like in business sense, if it's general warranties, it will be 12 to 14 months, and if it's tax or environmental, it will be 7 years. Also, specifically in the context of India, courts in India view indemnities as contractual liabilities and not tortious, and hence they are governed under section, if I'm not wrong, sections. I'm sorry, correct myself. 124 and 125. You might want to cross check this. I'm really sorry, but I mean, as far as I understand, sections 124 and 125 of the Indian Contract Act. And also, one more thing is the buyer must prove loss suffered to claim indemnity, unlike in UK law where warranties may give rise to strict liability. The last is, of course, your escrow mechanisms. Basically, let's understand what escrow mechanisms are first before I come to the purpose. Escrow mechanisms involve holding a portion of the purchase consideration in a neutral third-party account, or like an escrow, which is an escrow agent, to secure indemnity claims or post-closing adjustments. Now, the purpose of this is to deter misrepresentations and encourage compliance, provide for quick recovery route for buyer if indemnity claims arise, and it is useful where the seller is a foreign entity or individual promoter. So what are the key elements, right? So firstly, it's an escrow amount is usually 5 to 20% of the deal value. The escrow period is 12 to 36 months based on claim window. And there is a claim process, which will basically be notice, objection, and disbursement procedure agreed contractually. There are also governing rules, which are managed by RBI guidelines in case of cross-border deals and escrow arrangements under the Indian Contract Act. And as far as India is concerned, please understand that RBI restrictions apply for outbound remittances and foreign sellers. And escrow accounts for FDI exits must comply with foreign exchange management deposit regulations. Now, SEBI may impose escrow conditions for listed companies under the takeover code, which is as provided for under the SAST regulations. There's Now let's understand what the relationship between representation, warranty, indemnity, and escrow mechanism are, and how they are actually different in their function basis their role in risk allocation. Right? Because I think all of you will have questions on what exactly is then the difference between a representation warranty, representation and a warranty, or a warranty and an indemnity. So representations, understand, provide a factual basis for the buyer to evaluate the target. Warranties allocate contractual liability in case the facts are untrue, and indemnities provide post-closing remedy if representations or warranties are breached. Now, escrow mechanism is basically an enforceability tool to secure claims without litigation. Now, there are certain best practices in India that we look at, right? Now, firstly, there are granular warranties, which are crucial, especially in promoter-led or family-owned businesses where documentation may be weak. Then you also have a disclosure schedule to qualify warranties. Tax indemnities should be specific and broad due to frequent reassessments by Indian tax authorities. And also, you need to consider W&I insurance in high-value deals, though uptake in India is still limited. I think the last thing that I want you to note is that also you need to ensure that escrow terms are aligned with FDI and SEBI norms wherever applicable. Where applicable, I mean, I'm sorry, I correct myself. Yeah, I think we more or less covered everything on this topic. Before I move on to the next topic, are there any questions? Yes, Advocate HK Soni, is there a question?
No, sir.
No questions? Okay. So why is Gemini taking notes? It's very ineffective. Please don't use it, because I'm just saying, like, if you're, I think there's some Gemini it's taking notes here. It's not very effective. It's not like, sometimes it gives you wrong information also. So I think if you're like, it's great that there's an initiative towards it, but if you all want to like really like have a revision of the class, you can call me or you can text me. I think I've given my class email number, I'm sorry, my email ID and my mobile number in the previous classes. Email number interesting. I'm sorry. And we can always get in touch. But I don't suggest that you go through Gemini notes that are written as part of this session. Uh, but okay, coming back to our topic, third topic for today, which is drafting a shareholders agreements and your non-compete clauses. So, what is the purpose of a shareholders agreement, right? A shareholders agreement governs the rights, obligations, and inter se arrangements among shareholders, supplementing the articles of association of a company. Yeah, Toshika, sure. I'll do that. That's not a problem. I am not on the group, though I'll share it with Shriyanshu and he'll probably forward it to you all. I don't have any notes. I'm sorry. This is just slides where I've broadly written topics. I look at each thing and I explain it. But yeah, I will share the PPT. So okay, let's come to understanding what the key clauses of a shareholders agreement are. Now that we know what a shareholders agreement is, there's there's the first clause again will be your definitions and interpretations clause, which will basically be a standard clause for clarity on terms like shares, control, affiliate, dilution event, etc. Then comes capital structure and shareholding pattern, which will basically detail the initial ownership and post-investment capital table. Your third clause will be your board composition and governance clause, which will provide for a right to appoint directors, quorum and voting thresholds, and observer rights, if any. Then comes your reserved matters, which are clause, which are basically actions requiring affirmative vote or consent of certain shareholders. Sorry, like issuance of new shares, M&A, change in business, borrowing. Yeah, these. Then comes your transfer restrictions, which will basically be your lock-in periods, your right of first refusal and right of first offer clauses, your tag-along rights, and your drag-along rights. Just one thing, when you're writing transfer restrictions, you need to ensure consistency with Section 58(2) of the Companies Act of 2013, which recognizes contractual restrictions on share transfers among private company shareholders. Your sixth clause will be your exit rights, which basically will include your IPO or trade sale and strategic sale rights. And your put and or call options, of course. Subject to, of course, SEBI and RBI guidelines, especially in foreign investments. Then comes your information and inspection rights clause, which will basically provide for periodic financial business plans, inspection rights, etc. Then comes your non-compete and non-solicit clause, which is basically which is basically included in SHA for promoter obligations. Then comes your confidentiality and IP protection clause. Then your deadlock resolution mechanisms, which will basically be basis escalation to senior management or maybe uh, third-party mediation. Then comes your governing law and dispute resolution clause. Again, I don't have to really give details on this, but usually just note that arbitration is preferred even in a shareholder dispute. Then comes your amendment clause, which will basically specify that the shareholders agreement overrides prior understandings unless otherwise agreed. One thing is, you need to ensure that shareholders agreements are consistent with the articles of association, and under Indian law the articles of association is binding on all shareholders, and any conflict between the shareholders agreement and the articles of association can render the shareholders agreement unenforceable vis-a-vis the company. So the articles of association must be amended accordingly under section 14 of the Companies Act of 2013 before such shareholders agreement is signed. Then comes your non-compete clauses. So let's first understand the legal framework behind it before we get into its drafting. So non-compete clauses are governed by Section 27 of the Indian Contract Act of 1872, which renders agreements in restraint of trade void, except in limited exceptions. And courts have upheld non-compete clauses during employment or business sale, but post-termination non-compete clauses are generally unenforceable unless tied to goodwill sale or M&A. So where they are enforceable particularly will be during employment, where there's a restriction on engaging in competing businesses during the during the term. Then of course sale of business or shares, that is to say non-compete clauses are enforceable where part of the sale of goodwill or significant control of stake is in place. And this is from the Gujarat Bottling versus Company versus Coca-Cola case of, I think, 1995. If I'm not wrong. I don't want to cross-check the date, but yes. To repeat the legal, okay, okay, I don't think I need to repeat it. Uh, I think the next bit is what I'll go with. I mean, because I think these are fairly simple concepts. So the third, and like with the condition with regard to enforceability is, like promoter exit and M&A, where which is basically where non-compete clauses are enforceable, where promoters sell shares along with control and goodwill. So just to repeat all of them, uh, that like where non-compete clauses are enforceable in India. Firstly, during employment, where restriction on engaging in competing businesses during the term is enforceable. Second is sale of businesses or shares, where basically non-compete clauses are enforceable when a part of sale of goodwill or significant control or stake takes place, which was as provided for by the Supreme Court in Gujarat Bottling. Was it Supreme Court or Bombay High Court? You actually might want to check. I'm really sorry. I'm not getting at the upper hand, but I do remember that it was from the Gujarat Bottling Company case, Gujarat Bottling Company versus Coca-Cola. Uh, it is, I believe, of the Supreme Court itself of 95. Just let me just cross check this. Please give me 1 minute. Uh, I don't want to leave you with the wrong information. I have no shame in accepting that I might have misplaced the name of the court. Mm, 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 mm. Yes, it is the Supreme Court of India. My bad. The 1995 verdict is of the Supreme Court of India. It was initially in the Bombay High Court on like where it was first filed, and then it went to the Supreme Court. Uh, this position was was held by the Supreme Court of India itself. And then comes the promoter exit in M&A. Which basically indicates that which basically is that non-compete clauses are enforceable when promoters sell shares along with control and goodwill. So let's look at a sample non-compete clause in the context of an SHA or an SPA, and then I'll also show you a sample non-solicit clause. Let me put it on chat for your reference. Just give me 1 second. This is the clause that I have drafted. After this, I will share my screen and show you I think a share purchase agreement, and I'll just like indicate how clauses are drafted. Just got a sample ready before today's class. If you can see the non-compete clause. So you're basically saying that the promoter or the founder or the seller will agree for a period of 2 years from the like exit to not engage, invest, or operate, or maybe consult with or provide services to any competing business within a certain territory, like any competing business with the company that they were affiliated with within a specified territory. So just note one thing, that in this case, this restriction shall not apply to passive investment of not more than 5% in any publicly listed entity. To repeat, this restriction shall not apply to any passive investment of not more than 5% in any public listed company. So the parties agree that this restriction is reasonable and necessary for the protection of the company's business, goodwill, and confidential information. As far as non-solicit clauses go, this is for the so the like a non-compete is for a promoter, a founder, or a seller. The non-solicit also will come to a promoter, founder, or a seller, where they shall let me just give the sample clause to you. I think it'll be easier for you to understand. I hope you all can see. It's basically where these any of these three shall not, possibly engage in uh, any activity for uh, causing any gains without permission or loss without consent post the transaction, to in such a manner so as to jeopardize the company or the company's whatever economic position for a certain period of time.
Excuse me, sir.
Yeah.
Sir, can you just repeat it? I didn't quite get it.
For non-solicit or non-compete?
The latter one.
Okay. Can you see the sample clause that I've put on chat?
Yes, sir.
Yeah. So you're basically obligating a promoter, a founder, or a seller to not engage in any activity which is causing in any way alteration of the status quo of the business or the company, so as to let go of any of its contractual positions that were in existence prior to the happening of the share purchase or the share transfer.
Yes.
Do you understand? Do you want me to further clarify it?
No, I got it, sir. This was simply.
Yeah.
Thank you.
No problem. I mean, this will also come relevant in asset purchase as well if there's a change in control or change in there's a corporate restructuring, etc. By corporate restructuring, I mean like a change in the the composition of the board of directors. So this is one thing you need to understand that, again, as mentioned, Indian courts will not enforce non-competes that are unreasonably wide in time, geography, or scope. Like the restriction under Section 27 of the Indian Contract Act of 1872 will apply. Excuse me. And then, of course, you have to tie it to consideration often because you need to ensure that it forms part of sale consideration or employment compensation. And also, when you use words like competing business or territory, you need to define it clearly within the clause or as part of the definitions clause, basis which the non-compete or non-solicit clauses are drafted. Non-compete clauses, rather, for competing business and territory are drafted. Also, by way of note, you can understand that for shareholders agreement, the focus should be on alignment with Companies Act, FDI laws, and the Articles of Association, ensuring enforceability of transfer and hence ensure enforceability of transfer and governance provisions. But for non-compete clauses, you need to structure them around business sale or employment period and avoid broad post-termination restrictions unless sale of goodwill or control is involved. I'm sorry, my bad. I think that's the end of the topics for today, but I think I'll just quickly, as part of the last exercise of today, I think I've been asked to take you all through a sample SPA, understand what the key clauses are. So I've curated a few key clauses that I will be taking you through. Just give me 1 minute. Let's go. Can you all see the Word document? Can somebody please confirm?
Yes, sir.
Yes,
Cool.
sir.
Thanks, Ajay. Thanks, Ria. Thanks, Muskan. All right. So you can see the first being your first part of the agreement, indicative of your purchaser's full name, your seller's full name, and your target company name, which is basically identification of the parties. Then comes if you look at if you look at A, you give full details of the shares and you indicate the nature of those shares, right? You're giving the number of shares, You're giving the nature of the shares, which are paid up equity shares, and you are also indicating what percentage of the issued and paid up share capital they are of the company, and what exactly is the purpose of the agreement, which is for share purchase, that is highlighted in B. Then comes your key clauses, which is first your sale and transfer of shares clause, which will indicate terms of the agreement, basis terms of the agreement, that there is an agreement to sell and hence transfer. And of course, the consideration is also specified, that is the amount. And that also makes a reference to clause number 3, which is basically the purchase price and payment, which is you basically indicating how the amount is going to be, paid. And this is where you're also involving the escrow agent. But yes, let's come to this after clause 2. So then comes your conditions precedent clause, which will basically indicate like certain regulatory approvals that you have to undertake before the share purchase is deemed to be, the sale of shares rather, is deemed to be successful. These will be regulatory approvals if needed, and also to ensure that there is no material adverse change in the business of the company, because if there is, this share transfer will deem to be void, and the shares will go back to the name of the company, and the amount that has been the consideration that has been transferred by the purchaser has to be returned to the purchaser. And of course, the completion of due diligence onto the satisfaction of the purchaser also has to happen. Then your purchase price and payment will indicate by what date it should be paid and how it should be paid. Then you have your representations and warranties, which basically see, like we discussed, look at 4.1. 4.1a, it has the full power and authority to enter and perform into this agreement. It gives the stance of the company. Then this agreement is a valid and legally binding obligation, is what both parties are agreeing to. Then the seller is in 4.2. If you see in 4.2a, the seller is attesting to their title over the shares, because they say that the seller is the sole legal and beneficial owner of the shares. And you're also showing that there's no third party claim over the shares, because you're saying in 4.2b that the shares are free from encumbrances. And of course, you want to indicate legal compliance. So in 4.2c, the seller is saying that the company has complied with applicable laws. Now, beyond your representations and warranties, you might, at many a time as a purchaser, you might want to secure yourself. So you're asking for an indemnification. So that's your clause number 5, which is your indemnity clause, which is basically like indicating that the seller is agreeing to indemnify and hold the purchaser harmless against any losses, beyond what the purchaser could see through their reasonable due diligence. Or at the same time, of course, both of they can arise in furtherance of two aspects. One is breach of these representations and warranties, or B, of course, any non-fulfillment of any covenant or obligation. So non-fulfillment of any covenant or obligation is things that may arise beyond the scope of what exactly were included in the representations and warranties and the purchaser's due diligence that was undertaken reasonably. Now, of course, many of you will have the question that, buyers can purchase without even spending on due diligence, can simply go ahead and purchase those shares, and they can profit out of it. And if there's any liability, they can have a representation and a warranty and indemnity clause there. But here, if you see now in the process of negotiation, if in a case like this, the seller can go to the court. The seller goes to the court and says that this is what we could reasonably come to, and it was a genuine error on our end to not disclose this, while the seller is going to still be held accountable in the fact by the very simple principle of ignorance of law is not an excuse. If there is a material or a factual disclosure which would have been important for the buyer to take a commercial decision for advancing the business, then the buyer can't go to the court. The buyer can't go to the court and tell them that the seller didn't disclose it, or the purchaser can't go to the court and say the seller didn't disclose it, because the court will then say that the court will then apply the very simple legal maxim that you have studied, which is buyer beware, caveat emptor, and tell them that it was you were obligated to undertake a reasonable diligence, and provided, of course, the seller is able to establish that they acted in good faith. So yes, it's a big shot, but if you are ever representing a seller in this unfortunate situation, just understand that the seller can be remedied, provided you as a lawyer are able to show that your client, the sellers, were acting in good faith, and whatever they did to the best of their attempt or best of their efforts, and it was the buyers who didn't purchase, or purchasers who didn't undertake a reasonable diligence exercise. Then of course you have your closing, on that is the where and how the agreement will where and when the agreement will be closed. And of course your post closing obligations, which is the seller delivering duly executed share transfer forms, the purchaser delivering the purchase price, of course subject to escrow, and the company registering the transfer of shares. Then you have your clauses like confidentiality, governing law and dispute resolution, and of course the parties signing it, which are the purchasers, the names and signatures, of course, which are the purchasers, the sellers, and the authorized signatory on behalf of the company whose shares are being transferred. These are roughly, this was a very simple share purchase agreement. Usually share purchase agreements go on pages, go into like multiple pages, because your representations and warranties is so much in depth and so much in detail basis what the due diligence has been. So this was just like a framework of what a share purchase agreement looks like. Like, I mean, of course, the clauses being as basic as they could be. Do you all have any questions? I think everyone's mastered shareholders, share purchase agreements, and the drafting exercise today. I don't, but of course, I don't think there are any questions. But of course, if there are any, you can. I think I've shared my number and email address from in the previous classes. You all can reach out to me. I'll be more than happy to help you. I think someone had reached out to me after last class, and I think we had a good discussion on. Ajay, it was you, right? I don't remember who it was. I'm really sorry.
No, sir, it wasn't me.
I think someone had
Asked you
texted me.
about the book building method. You said it's.
That is next session. Yes. Someone had texted me, I think after last class. I think we had a good discussion on that example of leveraged buyout, where I think he had like asked. Oh, yes. I am so sorry. My wife completely forgot. But yeah, that's it for today. And I assume that there are no further questions because I don't see anybody unmuting and asking anything. So yes, over to you, legal specs.